In the previous section, we examined the purpose and impact of the Arizona Anti-Deficiency Statute, which was enacted to prevent homeowners from facing further financial hardship after foreclosure. We learned that not all properties qualify for this protection, and the statute specifically outlines the types of real estate that are exempt from deficiency judgments. In this section, we focus on those qualifying property types and the legal distinctions that determine whether a borrower is protected under Arizona law. Arizona's two primary anti-deficiency statutes, ARS, paragraph 33, 729, and ARS, paragraph 33, 842G, both limit a lender's right to seek a deficiency judgment, but they apply in slightly different contexts. ARS, paragraph 33, 729, applies to judicial foreclosures, while ARS, paragraph 33, 814G, applies to non-judicial foreclosures, which are more common in Arizona because they involve the trustee's sale process rather than a court proceeding. Despite their procedural differences, both statutes protect the same types of residential properties when specific conditions are met. To qualify for protection, a property must meet three key requirements. First, it must be a one-family or two-family dwelling. This includes single-family homes, condominiums, townhouses, and duplexes. The property must have a structure intended for residential use, not vacant land or commercial buildings. Second, the property must be 2.5 acres or less in size, ensuring that the statute applies only to typical residential lots, not to large parcels or ranches used for business purposes. Third, and most critically, the property must be used as the borrower's personal residence, and the loan must be a purchase money loan, meaning the borrowed funds were used to buy the home, not for refinancing or secondary purposes. For example, a homeowner who purchases a single-family home in Gilbert for personal use with a conventional mortgage is protected under the Anti-Deficiency Statute. If the homeowner defaults and the property is sold at a trustee's sale for less than the amount owed, the lender cannot pursue the homeowner for the remaining balance. However, a developer who purchases 2 acres in Chandler to build and sell homes would not be protected because the property was intended for resale and not personal residence. Another example involves a duplex in Mesa. If the borrower lives in one unit and rents out the other, the entire property remains eligible for protection because it meets the two-family dwelling limitation. Conversely, if the borrower rents both units and lives elsewhere, the property no longer qualifies. The courts have interpreted used as a dwelling to mean intended for personal occupancy, not merely owned by an individual. This interpretation was clarified in the Arizona Supreme Court case, Mid-Kansas Federal Savings and Loan Issues Dynamic Development Corp. DARS, 1991. The court held that the statute's protection does not extend to developers or speculative investors who build or acquire homes for resale, even if the properties meet the acreage and dwelling requirements. The court emphasized that the legislature's intent was to protect consumers who purchase homes to live in, not to provide financial safeguards for business enterprises. In Baker v. Gardner, 1988, the Arizona Supreme Court reaffirmed that lenders could not circumvent the anti-deficiency protections by waiving foreclosure and filing a lawsuit for the unpaid balance. The decision underscored the strong consumer protection purpose behind the statute, to ensure homeowners do not suffer double hardship, losing their home and remaining personally liable for the debt. Properties excluded from anti-deficiency protection include vacant land, because it does not qualify as a dwelling, commercial properties, such as offices, warehouses, or retail buildings, investment and rental properties, unless the borrower occupies a portion as a personal residence, large agricultural or development tracts exceeding 2.5 acres, refinanced or non-purchase money loans, including home equity lines of credit used for non-acquisition purposes. It is also important to note that the size of the home does not affect eligibility. Only the use, structure type, and land size do. For example, a 6,000 square foot luxury residence on a 1-acre lot qualifies for protection. while a mobile home on 10 acres of desert land would not. The Commissioner's Rule R4 28 1101B requires real estate licensees to exercise reasonable care when assisting clients who are selling or purchasing distressed properties. Agents should not offer legal interpretations of deficiency protection, but must recognize when it may apply and refer clients to qualified legal counsel. Understanding the property types protected under this statute allows licensees to communicate more effectively with clients in default situations and prevent misinformation. Discussion. Why does the anti-deficiency statute exclude vacant land and commercial property? Answer. Because the statute is intended to protect consumers using property as a personal residence, not investors or business owners using land for profit. Would a duplex qualify for anti-deficiency protection if the owner lives in one unit and rents out the other? Answer. Yes, because it is a two-family dwelling used partially as the borrower's residence. Does refinancing a primary residence affect anti-deficiency protection? Answer. Yes. Refinancing or taking out a home equity line of credit may remove protection because the loan is no longer considered purchase money. Review summary. Arizona's anti-deficiency statute provides financial protection for homeowners who lose qualifying properties through foreclosure. To be protected, the property must be a one- or two-family dwelling on 2.5 acres or less, used as the borrower's personal residence, and financed with a purchase money loan. These criteria exclude commercial, investment, and large properties. The statute ensures that ordinary homeowners are not burdened with debt after foreclosure, promoting fairness and stability in the housing market. Real estate professionals must understand these distinctions to properly inform clients of their rights and responsibilities, while ensuring compliance with Arizona law and Commissioner's rules.